2003. And so what the Roberts Supreme Court has done in the area of campaign finance is itself a reversal of precedent. So reversing precedent is not something that the Supreme Court will refuse to do. They're reluctant to do it in part because of the rule of law. And one of the precepts of the rule of law is that you treat similar cases similarly. And so it will take some courage on the part of the newly reconstituted Supreme Court, once we get that ninth justice, to reverse or cut away at existing precedent. But they can do it.
Thanks so much for that call, John. We're going to go now to Brooke in Anna Maria. Hi, Brooke.
So the Supreme Court has ruled on this recently, and I think the basic holding in the NLRB decision recently was that the Senate really needs to be out of session for there to be a recess appointment, which has encouraged the Senate to have these sort of bogus days when they are seemingly in session, but they're not doing anything. But if they can continue to do that, then it thwarts the ability of the president to make a recess appointment.
Did that answer your question?
We might get a lot of action around the Christmas break of Congress.
Brooke, thanks so much for your call. 813-239-9663 if you'd like to join the conversation. We have some people on the line, but we do have a couple of open lines, so if you want to call in now, dj@wmnf.org if you'd like to send us an email. 813-433-0885 is the number if you want to text us. And I'm going to go to a comment that came in at the end of Rob's show. And he's this person, I don't know where he's calling from, the 813 area code, says, amazing that one of the gentlemen on the panel mentioned that if David Jolly had enough money, he can win the election. How sad that to win an election depends on how much money you have to spend, not much of a democracy. And since that did come in the last show, but I think it's really relevant to our conversation here, and we haven't gotten too much into how corporations influence politics yet, but that's certainly where we're going in this conversation. So maybe this can be a branching off point, comparing how much money a candidate has, especially early on in an election, is just about the biggest thing that people talk about in the news, and it really has an impact on whether they have a likely chance of winning or even competing in an election. What do you know about the amount of money in politics and how candidates get that money and how competitive they are with respect to how much money they have?
Sure. So when you look at congressional elections over the past 2 decades, for the most part, the candidate that has the most money wins. And the stats jump around a little bit, election to election, but the general rule is 90% or more of the winners are the candidates who have the most money in the bank. And so you could think about why that is. Part of it is going to be the power of incumbency. So money tends to follow power, and incumbents tend to get reelected. These can be self-reinforcing mechanisms. And so if you are a campaign donor, it makes a lot of sense to back the incumbent because they are likely to win. And so then when they get reelected, they will feel indebted to you as a donor. But there are always the exceptions that prove the rule. And I think we may be seeing some of that in the presidential election this year, where Trump actually doesn't have that much money in the bank. And we'll see whether that translates into electoral wins or not. It's certainly translated to electoral wins during the primary. But as a general rule, if you look back since Watergate, it's the candidate who has the most money, even at the presidential level, who ends up winning the race.
Whereas Greg Pallas says the best democracy money can buy. 813-239-9663 is the number to call. If this person from the 917 area code would like our guest, Ciara Torres-Spelliscy from Stetson University College of Law, to comment on Buckley v. Vallejo, money as speech. What does that have to, how does that fit into this conversation?
Okay, so after Watergate, there was a huge revision of federal election law. The Federal Election Campaign Act, otherwise known as FECA, was passed, and that law was challenged in Buckley versus Vallejo. The Supreme Court splinters in that case. They can't decide on so many different aspects of whether it's appropriate for the Congress to do what it did in trying to hem in money in politics. And so it's a decision that upholds most of FECA, but it invalidates a really key part, which is a limit on expenditures. And the limit on expenditures, when the court is talking about it, they think of expenditures of money as pure speech. And they never actually say the words money is speech, but they get sort of dangerously close to that. And so I think in the popular imagination, Buckley stands for the proposition that money is speech. Now, fast forward to the Roberts Supreme Court, they seem to take the money is speech reasoning to very dark conclusions. I think that's part of why they rule in Citizens United the way they do. They also rule similarly in a subsequent case called McCutcheon, that you can't limit how much an individual can give to basically all members of Congress or all presidential candidates and political parties. So there used to be an aggregate limit that applied to individuals who were spending in politics, but after McCutcheon, there is no aggregate limit for rich individuals who want to basically spend money on an entire congressional delegation if they want to.
Well, thanks for that call and that email and text message as well. Let's try Ernest in Temple Terrace. Hi, Ernest, you're on the air. What would you like to say? I almost said something that wasn't very neutral, but let's just say I'm guessing that we won't need to have a show about David Duke because I'm guessing that he won't be politically relevant after November. But I certainly played a lot of his campaign announcement the other day. I don't know if you heard it Friday afternoon. So David Duke, of course, we're talking about the former Grand Wizard of the KKK, who is now running for U.S. Senate. He announced on Friday in Louisiana, and he put out a video campaign announcement that talked about how other groups have their special interests, people fighting for them, and so he was out there and he wanted to make sure there was someone out there who was fighting for European Americans. And he goes on from there, in case that's not shocking enough, he goes on from there, and I played a little bit of that on Friday. My guess is we won't need to be playing much more about him after. Yeah, well, he's called out Trump and Trump supporters as saying one of the reasons why he felt emboldened to go ahead and run. So, Ernest, thanks so much for your call. I appreciate it, and I'll definitely keep an eye on that race. All right, thanks so much. And my name is Seán Kinane. I'm the host of MidPoint Monday. My guest is Ciara Torres-Spelliscy. She's a professor at Stetson University College of Law. Her book is Corporate Citizen, an argument for the separation of corporation and state. We have Kirk in Tampa. Hi, Kirk. Did you hear the question? Are political parties established corporations?
Ah, interesting. I haven't looked into the status of the two political parties. It is entirely possible that they are organized as nonprofits, yeah. So go ahead.
All right, thank you so much, Kirk. Do you have anything to add to that?
So I think one thing that's sort of interesting about the U.S. Supreme Court is they are very protective of the two major parties. So on occasion, you will get challenges by third parties or independent candidates, and usually what they are trying to challenge is things like being able to be included in political debates, or having ballot access, as in will they have a line on the ballot for, say, the Green Party. And the Supreme Court is really hard on third parties and independent candidates. They seem to be very worried about influence fracturing among lots of different political parties if it were really easy to get on the ballot, or if it was really easy to get on the debate stage. But it does raise this sort of weird question about, well, why should the Supreme Court actually protect the two major parties? Maybe the healthier thing for democracy would be actually opening it up and allowing for more third parties and independent candidates to run.
And I think part of the rationale for having a Supreme Court justice be appointed for life is so that they feel independent from their political benefactors, I guess. But the truth is, at one point, they had to be very popular with someone who's a political person, the president, and they had to be chosen by that president and then confirmed in a political process in the Senate. So it makes you wonder, like how much influence there still is of the parties and of these individual politicians over the Supreme Court justices who are still appointed for life.
Indeed. And there's a really interesting case out of California where California tried to make it much easier for voters to basically vote for whomever they wanted to, despite their political affiliations. And Justice Scalia, when he was alive, wrote that opinion in the Jones case. And it's clear from that opinion that what Justice Scalia is concerned about is having the Republican Party be basically taken over by independent voters. And he sees that as like a nightmare scenario. From the point of view of the voter, what I think California was trying to do is make it easier for a voter to vote for whatever candidate they found appropriate and attractive. But the Supreme Court totally discounted the role of, or the wishes of the voter in that case, and all they could focus on was what would this mean for the two major political parties if all these independent voters could basically associate with whichever party they felt like that day? ...
God forbid, right? 813-239-9663. Bob in Tarpon Springs, you're up next. What's on your mind, Bob?
That is actually a very astute question. So one of the things that drives corporate scholars nuts about both Citizens United and Hobby Lobby is that it doesn't respect the corporate form. And you're right, the way that corporate law treats the corporate form is that the corporation is separate from its incorporators, or the corporation is separate from its shareholders, it's separate from its board of directors. But when you have either Hobby Lobby or Citizens United, the way the Supreme Court views a corporation is as an association of individuals. And so they sort of see through the corporate structure to those underlying individuals, and then they give rights to the corporate structure as if it were a stand-in for the individuals, which is not at all the way that corporate law treats the corporate form.
All right, thanks so much, Bob. That's certainly contributed to the conversation there. I appreciate that. So that's Bob. Thank you for that. And we'll go now to Will in Gibsonton. What's on your mind, Will?
Yeah, this is a conversation that leads right into the reason we need a constitutional amendment when it comes to corporations in person, them being persons. Because the courts, no matter what court it is, and especially the Supreme Court, is always